Hello everyone, my name is Mosam and I'm a research scholar at Lovely Professional University. Age of Criminal Responsibility and Juvenile Justice in India. This is the topic of my research paper. So, introduction. Juvenile crime is not naturally born in the child, but it is largely present in him because of the surroundings that he is brought up in. His own absurd actions or simply lack of discipline and proper education. The youth is regarded to be one of the greatest asset of a country. If this population is not well groomed, the future of the country would certainly not be very bright. We as a whole have a moral as well as an ethical responsibility to provide all children with a healthy environment to study and grow in. So, who is a juvenile? Juvenile refers to those adolescents who have not yet achieved the age of majority or who are under 18 years of age. And what is juvenile delinquency? Juvenile delinquency refers to participation of minors in illegal crimes. When a person deviates from the normal course of his social life, his behavior is termed as delinquent. In other words, when a juvenile's action proved to be dangerous towards the society and for him, he may be called a juvenile delinquent. Act of delinquency may include running away from home, use of inappropriate or vulgar languages, committing sexual offenses, etc. Meaning of criminal responsibility. Responsibility is often used synonymously with liability, yet in criminal law, the two words have strictly different interpretations and meaning. Liability is imposed by law, and whether it is civil or criminal, there is always a factual basis for imposing liability. Basic element or prerequisites for imposing liabilities are harm, conduct, and causal relationship between harm and conduct. Such conduct must be voluntary. Responsibility, on the other hand, can be recognized as the basis of liability and other element necessary to constitute criminal liability is mens rea and criminal intent. Moving on to the next slide. Relevant provisions of Indian Penal Code. In India, the relevant provisions regarding minimum age of criminal responsibility are contained in section 82 and 83 of the Indian Penal Code 1860. Section 82 of the Indian Penal Code lays down that nothing is an offense which is done by a child under 7 years of age. Further, Section 83 of the IPC lays down that nothing is an offense which is done by a child above 7 years of age and under 12 who has not attained sufficient maturity of understanding to judge of the nature and consequences of his conduct on that occasion. Determination of minimum age. With regards to determining international standards on setting the minimum age of criminal responsibility, guidance has been provided by the Beijing Rules, which recommends that any minimum age of criminal responsibility shall not be fixed at too low an age level, bearing in mind the fact of emotional, mental, and intellectual maturity. This rule largely indicates that the modern approach is to consider whether a child can live up to the moral and psychological components of criminal responsibility, that is, whether a child, by virtue of her or his individual understanding, can be held responsible for essentially antisocial behavior. Article 1 of the United Nations Convention on Rights of Child states, for the purpose of the present convention, a child means every human being below the age of 18 years, unless under the law applicable to the child majority is attained earlier. Reason for fixing the age at 18 years. The age of 18 years has been fixed on account of the understanding of experts in child psychology and behavioral patterns that till such an age the children in conflict with law could still be redeemed and restored to mainstream society instead of becoming hardened crimes in future. Legal basis. The basis of fixing of the age till when a person could be treated as a child at 18 years in the Juvenile Justice Act 2000 was Article 1 of the United Nations Conventions of the Right of Child adopted in September 1990. Scientific basis. The scientific data that indicates that the brain continues to develop and the growth of the child continues till he reaches at least the age of 18 years, and that it is at the point of the time that he can be held fully responsible for his actions, along with physical growth, mental growth, and equally important in assigning the maturity of a person below the age of 18 years. So let us talk about the causes behind juvenile delinquency. There are often varied causes behind juvenile delinquency, and the problem cannot be attributed to one factor. There are biological causes, hearing problem, speech problem, excessive strength, etc. can cause frustration or irritation to the juvenile who may see crime as an outlet to vent out. Social environmental causes, family background, and upbringing play a vital role in shaping the personality of an individual. Likewise, children facing violence at home or those coming from broken families are more likely to commit crime. Considered broken homes with other factors such as poverty, lack of recreational facilities, disorganized families, including family conflicts, and neglect of children to be the important factor causing juvenile delinquency. Psychological and personal causes. While intelligence level vary, the personality traits such as neuroticism, psychotism, frustration, and maladjustment appears to be important causative factors of juvenile delinquency. Need for change. What is the need for change? The demands to lower the age of criminal responsibility under the Juvenile Justice Act 2000 in India were first made frantically in the year 2013. On the ghastly night of the 22nd of December 2013, a young woman was gang raped on a moving bus in the most brutal manner possible, which ultimately resulted in her death. Out of the six perpetrators, one was a minor at the time of the commission, making him, in the eye of law, not mature enough to reason his action and thus be left off scot free, thus triggering the nation's rules regarding the age of criminal responsibility. The Nirbhaya case incident led to mass outrage and demand to convict juvenile between the age of 16 to 18 years in an adult manner for heinous offences committed by them. This is the Justice Verma Committee report. Justice Verma Committee was constituted to recommend amendments to the criminal law after the Nirbhaya rape case. The committee did not recommend the reduction of age of juvenile in conflict with law and maintained it at 18 years. Stress was laid on how to give age is based on sound principles recognized internationally and contained in the provisions of Indian Constitution, and there is a definite thought process which went into its enactment. Ultimately, the committee emphasized on reformative approach for delinquents rather than harsh punishment, which would make it all the more difficult to integrate them with mainstream society, thereby defeating the very purpose of Juvenile Justice Act 2000. Analysis of 2015 amendment. Following the mass outrage on reducing the age of Juvenile Justice Act 2015 was enacted, which came into force in January 2016. The most important change is that juvenile of the age group of 16 to 18 years are tried to be like an adult for heinous and barbaric offences committed by them. Under the provision of this new act, the court shall make sure that the child who is found guilty of heinous crime shall be sent to a place of safety till the age of 21 years, and afterwards the person shall be shifted to the jail. Juvenile Justice Care and Protection Act 2015 has reversed the well founded principle of juvenile justice by allowing Juvenile Justice Board to waive the right of children above the age of 16 years who have committed a heinous offense into the criminal justice system. This means the treatment of juvenile will depend on the type of offense committed rather than the situation. The situation in different countries can be explained as follows. In USA, there is no uniform standard regarding the minimum age of criminal responsibility, and thus different states have different standards. In most states, 7 is fixed as the age of criminal responsibility. However, the age has been fixed to 6 years in North Carolina. In most US states, the jurisdiction of juvenile court is automatically waived when a child above a certain age, usually 13 or 15, commits a violent or other serious crime, and the case is automatically transferred to the adult court. In England and Wales, the minimum age of criminal responsibility in England and Wales is 10 years, and those below the said age are considered to be dolly incapax and thus incapable of having any mens rea, which is similar to the provisions of Section 82 and 83 of Indian Penal Code. In Canada, the age of criminal responsibility has been set to 12 years. Youth between the 14 and 17 years may be tried and sentenced as adults under certain situations. Conclusion: the government did not take a well thought out approach when it reduced the age at which juveniles who were involved in heinous crime could be tried as adult criminals. The punishment of adolescent children as adults and the trial of adolescent children as adults. The rehabilitation of juvenile offenders should be the topmost priority. In order to approach and treat juveniles, it is necessary to comprehend their adolescent minds. It is not sufficient to establish a demarcation based on age and type of crime, as this will accelerate the onset of behavioral issue in children. The juvenile justice system as it is now needs to be improved to close the loopholes and fix the problem. Instead of using punitive law, children should be treated with the utmost care. The government should work to impose and eliminate the factors that have led children to commit such crime, provide better reformative measures for children already in the system, and raise public awareness of the law so that the people can prevent their children from committing any offense by better understanding the system and its rules. Recommendations: because of the issue with the current Juvenile Justice Care and Protection Act 2015, it is necessary to modify some of the Act's provision. Better implementation is required. Juvenile Justice Act 2015 has the same issue with implementation as Juvenile Justice Act 2000. Finding competent authorities to hire. The absence of competent authorities like psychologist, psychosocial worker, social worker, probation officer, and others is one of the major drawbacks. It is possible to have a better understanding of the circumstances that led to the criminal behavior of the children in order to deal with them. Filing the official positions that aren't full. It has been discovered that staff in various observation and special homes are insufficient. The genuine staff present in the home led out for kid in especially not exactly the requirement. These are the references of my research paper. Thank you.